So what should you expect for your first appearance on a domestic violence offense? In California, the first appearance for a domestic violence offense is typically called an arraignment. And an arraignment in California is basically you hear about a bunch of rights that you have and you receive the charges that are against you. That first appearance is not a time for you to argue your case in front of a judge or in front of the DA. It's just you're advised of your rights and your charges. The following is going to happen on your first appearance or your arraignment. That's when the accused has to appear to court for the first time. For a domestic battery or domestic violence case, the person who is accused of the offense does have to appear personally for the hearing. You're going to get a paper. That paper is going to be called a criminal complaint. It's going to list the charges that are against you. Third, you're going to be advised of your rights, like your right to remain silent, your right to a lawyer, your right to compel witnesses. A lot of times you have an attorney, they're going to waive reading those rights because they'll probably tell you those rights before the hearing. Fourth, the attorney who's representing you is going to appear and tell the judge they're making a general appearance on your behalf. Fifth, they're going to discuss custody status. The judge is going to determine if you're let out on your own recognizance or if bail needs to be set. If you already bailed out, then the bond is going to attach to your case. But if the judge wants to set bail, they might remand you into custody. Sixth, the judge is going to discuss if protection orders are needed. Typically in all domestic violence case, a protection order is going to be set. That it means you're not going to be able to make contact with the victim in the case, or in other cases, it would be a peaceful contact order where you can have peaceful contact. Seventh, the attorney is going to get the initial discovery. That means all the police reports and the narratives on this case. The attorney is going to make a plea for you. Typically, they're going to plead not guilty and deny any and all allegations. And last, the court's going to set future court dates. A lot of times you don't get all the discovery in the case. That means all the evidence. So the attorney may need to appear again in order to get the discovery or make further negotiations with the prosecutor. Those are the future court dates, and those future court dates may include your jury trial date, where you try the case in front of a jury. So as you can see, there's a lot that are addressed on your first court date. At least 9 things we counted here. There may be more things that might be addressed on that day. So that way, when you show up, be sure just to listen to your attorney and follow their lead. Good luck.